Get ready for the dictation. 5 seconds. Start. The bill was passed by this House and the Rajya Sabha. It was notified as a law and the provisions came into effect on the 1st of December 2016. So, effectively, for almost a little more than a year, this has been in operation. Since this is for the first time in India that a law of this kind was being put into operation, this was necessary. It is because those who cannot run businesses and have literally made the businesses insolvent, an exit had to be found for them. In order to save the employment and save the enterprises itself, an effort has to be made in the first instance to have a resolution under which those enterprises themselves could be saved. If a resolution is not possible, it is only then that in extreme cases one goes to the extent of dissolution. The functioning has revealed that certain improvements, etc., and changes were necessary. If we look at the language of the bill itself, I think there was some clarity which was required with regard to the definition of the word resolution applicant as to who can apply for resolution itself. And that clarification has been brought in clause 3 of the amended bill, which came in the form of an ordinance itself. Clause 4 itself deals with the eligibility criteria that can be fixed. The core and the soul of this new ordinance is really clause 5, which is section 29A of the original bill. I may just explain that once a company goes into the resolution process, then applications would be invited with regard to the potential resolution proposals as far as the company is concerned or the enterprise is concerned. Now, a number of ineligibility clauses were not there in the original Act, and therefore 29A introduces those who are not eligible to apply. For instance, there is a clause with regard to an undischarged insolvent who is not eligible to apply. A person who has been disqualified under the Companies Act to act as a director cannot apply, and a person who is prohibited under the SEBI Act cannot apply. So, these are statutory disqualifications. And there is also a disqualification in clause C with regard to those who are corporate debtors and who, as on the date of the applicant making a bid, do not operationalize the account by paying the interest itself. That is, you cannot say that I have an MPA. I am not making the account operational. The accounts will continue to be NPAs, and yet I am going to apply for this. Effectively, this clause will mean that those who are in management and on account of whom this insolvent or the non-performing asset has arisen will now try and say, I do not discharge any of the outstanding debts in terms of making the accounts operational, and yet I would like to apply and get the same enterprise back at a discounted value, for this is not the object of this particular act itself. So, clause 5 has been brought in with that purpose in mind. And clause 6, which is the other important clause, brings in that the committee of creditors, which by 75% majority has to approve a resolution process, will see in terms of clause 6 of the feasibility and the viability of the proposal which has been made for the resolution itself. It is not bound to accept any or every proposal that comes up before itself. It must see that it must be a proposal which itself is feasible and viable, which inspires confidence, and it is only then that a committee of creditors will approve that. Now, these are improvements. Since I said that this is for the first time India has entered into this jurisprudence, it is a learning experience for us also. 1 year after operationalizing it, all the concerned stakeholders have been consulted and these amendments have been brought in. The reason why the ordinance was brought in because a large number of cases are already pending resolution mechanism itself, and therefore if we had not immediately brought in, then even the ineligible persons who are sought to be made ineligible under this would have started applying for the resolutions itself. Therefore, in order to give it an immediate effect, an ordinance to this effect was necessary, and that is the reason why the ordinance was brought in. This bill is also to disallow the sale of property to a person who is ineligible to be a resolution applicant in the case of liquidation of the corporate. Madam, earlier, if a company defaulted, there were at least 4 different legal routes available to the debtors and the creditors. This could lead to multiple negotiations and multiple penalties, etc., for the debtor, compounding his plight. Moreover, such parallel proceedings had also given rise to numerous instances of conflict between the laws. 4 different agencies, the High Courts, the Company Law Board, the Board for Industrial and Financial Reconstruction, and the Debt Recovery Tribunals, have overlapping jurisdictions, giving rise to the potential of systematic delays and complexities in the process. This new bill addresses all these issues by bringing a uniform code. The current insolvency proceedings take months, if not years, and the average time is 4 years. This delay can acutely devalue the assets involved, thus making the insolvency negotiations redundant. The new code seeks to keep the role of educator to the minimum. Currently, only 25% of the asset value is recovered by the creditors even after the liquidation process. That is a matter of great concern. Now I am coming to how to deal with it. Our public sector banks and financial institutions find themselves in pitiable condition, and the rising NPAs and mounting stressed assets have also eroded their profits, as has been brought out in State Bank of India reports. The report has also brought out certain irregularities in providing loans to corporate houses. All these issues have been taken into account in this bill for effective solution of the problem being faced at present, and I am hopeful that we will be able to implement the provisions more effectively. With these words, madam, I thank you very much. Stop.